Luigi Mangione's attorney says some evidence in the Pennsylvania probe, where Luigi Mangione was arrested at McDonald's, should be tossed because of an allegedly illegal search. Let's talk about that. Today's video is going to be discussing your Fourth Amendment rights under the Constitution, what it means to conduct a stop versus an arrest, your Miranda rights, inventory searches, and the fruit of the poisonous tree doctrine. A lawyer for Luigi Mangione, the 26-year-old accused of killing the United Healthcare CEO, is attempting to throw out the evidence taken from his backpack and other belongings collected during his arrest, arguing he was illegally stopped and searched by the police. They're also arguing that his statements made during, the arresting process should also be thrown out. In this motion, Mangione's lawyer, Thomas Dickey, great name, said he seeks to toss more than 24 items, including a 3D printed gun, a fake driver's license, and a notebook collected by police when Mangione was arrested at a McDonald's restaurant in Altoona following an intense manhunt. The filing reveals for the first time specific details of local police's confrontation and arrest of Mangione, and a detailed list of the materials found in his backpack. So this is called a motion to suppress, and that's, what usually happens in criminal cases where an individual's Fourth Amendment rights are violated. The Fourth Amendment provides you with protections in your home and to one's personal property from warrantless searches. It's alleged that Luigi was stopped, his backpack was searched in a warrantless search, and that evidence should be thrown out. And we're going to look at that motion here in a moment. Mangione was questioned by officers, was not read his Miranda rights, or given any information as to why he was being held for more than 15 minutes. And chat, I don't know if you've ever experienced 15 minutes with a cop before, but 15 minutes with police feels like a couple hours. So the actual article is a little sparse about the legal justification. So let's look at the motion, which we have, because I'm a prepared lawyer boy. So this is in the Common Pleas of Blair County, Pennsylvania, Commonwealth of Pennsylvania v. Luigi Nicholas Mangione. I don't understand why it's, there's an error right there saying Luigi. So let's read the actual motion together, and then we'll talk about the merits of the motion. So we don't need to read about the petition for writ of habeas corpus. That's, just talking about the justifications for the charges. Forgery, firearms, not with a license, tampered records for identifications, possession, instrument of crime in violation of a misdemeanor of first degree, false identification, law enforcement officer. So this is different from his New York trial. He has a minimum two criminal cases going on right now. His New York case is about the actual, alleged murder of the United Healthcare CEO, while his Pennsylvania case is about, having this firearm on him, about having the forged license, possessing instruments of crimes. So let's talk about, the motion to suppress. On or about December 9th, 2024, about 9:30 a.m., defendant was approached at a McDonald's by two uniformed, armed, fully equipped police officers of the Altoona Police Department. Said uniforms explicitly exhibited badges and other identifying insignia indicating their identity as police officers. Defendant was seated at a corner dining room table that had a wall directly behind him and to his left. So he's in a corner. There's also another unoccupied chair to his immediate right. Defendant's only natural path was to his right. Upon their arrival, the officer immediately posted himself to the right of the defendant. So the cops come, they see Luigi in the back corner, and they block him in. The action was taken in order to detain or totally curtail the liberty of the defendant. These actions were performed to clearly exhibit the authority over the defendant. So, cops come in, they stop you from leaving, they're showing their authority over you. No explanation was given to the defendant relative to why the police approached McDonald's. At most, police indicated he had looked suspicious and had overstayed his welcome as patron at McDonald's. So, chat, the police are allowed to lie to you. If they're approaching you because they think you're Luigi Mangione, the most wanted man in America. They don't have to tell you that. That's fine. Defendant had been at McDonald's as a paying customer for 30 minutes. To it must be assumed defendant was being detained for an investigation to which he was not informed. So at this point, the cops come. He hasn't made an attempt to leave, but they're stopping him from leaving. The accompanying officer positioned himself next to Depweller's right and next to the dining room table. So now there's two cops blocking him from leaving. At no time did the two officers indicate the defendant was free to go, nor did they explain the reasons why the defendant was being detained. Here is where we have an issue. It doesn't say anything about Luigi asking if he was free to go. Remember, chat, if you're unclear if you're being detained or not, ask the police if you're free to go. If they're detaining you, they have to tell you you're being detained. You can't leave anywhere. Upon approaching the defendant, Officer Depweller immediately made commands and instructions to the defendant, including but not limited to, give them his identification, stand up, hands on his head. Chat, if the cops ask you for your identification, tell you to place your hands on your head, type 1 if you think they are detaining you. If they're blocking your ways of exit, if they're telling you to place your hands on your head, type 1 if you think they're blocking you. The totality of the circumstances, including but not limited to the positioning, demeanor, mannerisms, commands, directives, instructions, and other actions of the Altoona Police Department, showing that at the time the request for identification was made, the compliance with this request was required. So basically they're saying, yeah, they're telling you to put your hands on your head, give them your identification. You have to do that at that point. Any reasonable person in defendant's position would have thought he or she was being detained. Both police officers then continued to interrogate and question the defendant without any reading of his Miranda rights. The officers then performed what's called a Terry frisk. A Terry frisk is a pat down of someone in order to determine if there are any weapons on that person. You only need to have criminal suspicion to be able to do a Terry frisk. You're allowed to stop someone, and then, Terry frisk them. I would believe at the point they're not saying they're detaining you to avoid having to say that they're detaining you. Yeah, that's basically what's happening. The Altoona Police Department took possession and control of the identification materials. They took his ID from him and continued to hold on to them. The positioning of law enforcement officers and, keeping his ID, telling them that they're doing an investigation, signals to a reasonable person they're implicitly commanding the person to remain on the scene. Yeah, chat, if the police take your ID, you can't leave. Within minutes, other members of the police department arrived at McDonald's. Two more fully uniformed officers, another 3 to 4 officers also blocked the path. So now we're up to about 8 officers blocking his way out of there. A member of the Altoona Police Department questioned the defendant about whether or not a backpack, plastic bag, and other items belonged to the defendant. At that time, the Altoona Police Department seized the items and packages and placed them in an area behind law enforcement personnel. If tell you that you're not being detained, you're free to go, do you actually have to vacate? No. But, why wouldn't you vacate? And if they're telling you that you've overstayed your welcome, you should vacate because they're basically saying they're going to trespass you. Aaron, no reasonable person, in my view, would understand if the cops are keeping your ID that you're free to go. The Altoona police officers then stationed between themselves and the defendant and the items of property belonging to be the defendant. These items of property remained in the control of the Altoona Police Department. So they took his backpack and they kept a hold of it. In order for the defendant to exit the dining table and venture to the service area of McDonald's, he would have to pass no fewer than 7 to 10 guards or 7 to 10 police department members. There was an excess of 10 law enforcement personnel surrounding the defendant in the small dining area. No reasonable person would believe they were free to leave. During this period of custody, they kept asking him fucking questions. They made it clear that the defendant was in custody and that the action by the Altoona Police Department constituted custodial interrogation of the defendant. So what they're saying here is that by not allowing him to leave, by taking his ID, by having 10 officers gang up on him and then ask him questions, they're now interrogating him, and they haven't read him his Miranda rights. In excess of 15 minutes had passed, so they questioned him for 15 minutes during this time. And the defendant's unlawful seizure, containment of liberty, interrogation continued. He's still not getting any information on why he's being held or his continued curtailment of liberties. After approximately 15 minutes, he was advised by Officer Detwiller that he was officially under a police investigation. He was not read his Miranda rights. He then asked who he was, at which time the defendant replied he was Luigi Mangione, based. He was further interrogated by members of the Altoona Police Department. After approximately 2 minutes of interrogation, a member of the Altoona Police Department read him his Miranda rights. So nearly 20 minutes until he was given his Miranda rights. And then he was told that he was not in custody. He has 10 cops. He's been read his Miranda rights, which only happens when you're in custody. And then he's told, you're not in custody. The statement was materially false and contrary to law. He was asked if he wanted to continue answering questions, and they continued to question and interrogate him anyway. He said he didn't want to talk. He was then subjected to another Terry frisk. They pat him down again. He was placed in handcuffs, and then only then he was announced he was being detained. 20 minutes of being questioned by officers, being bunched up for 10 minutes. A photograph was taken of him by the agent of the Pennsylvania Office of the Attorney General. Approximately 7 minutes later, it's about 25, 30 minutes in total, he was placed under arrest for the crime of providing false identification to law enforcement, the fake ID. At the same time, members of the Altoona Police Department commenced a thorough search of defendant's backpack and other items. Luigi states that this search was illegal and unlawful in violation of the protections afforded by the Fourth Amendment. During the search of the backpack, they uncovered, they opened up with duct tape, said pack contained a computer chip, which is unlawful, and some other items that we will go to in a little bit. At the McDonald's, police also discovered a clip containing bullets, which was wrapped up in some undergarments. At that time, the Altoona Police Department decided to repack the backpack and take it to the Altoona Police Department for further searches and seizures. They found a 9mm handgun, mechanized upper receiver, suspected 3D printed suppressor, a red notebook, the manifesto, and a full list of seized items that are here. So I don't really want to get through more of this. A clip to, oh my God, let's not get in the clip versus magazine part. So let's look at Exhibit B really quickly, which is the items. This is Exhibit B. The red notebook manifesto, 9mm black ghost handgun, 1 U.S. passport, 3 debit cards for Luigi Mangione, homemade 3D printed silencer, $7,800 in U.S. currency, $1,600 in foreign currency, AAA batteries, USB from wallet, USB on necklace, receipts, pocket knife, screwdriver, zip ties, Best Buy receipt, medical face mask, 25 count, 2 more handwritten notes, a SIM card, a black laptop, a black jacket, green jacket, and lots of other clothing. Leggings, glasses, jeans. How big was this backpack? Jesus Christ. Chat, have you ever had a backpack that could fit a handgun, a notebook, like 6 pairs of clothes, like 10 grand, face masks, manifestos, 4 different jackets and gloves and belts, and Jesus Christ. He must know how to pack well. Yeah, long haul hiking backpack. Yeah, true. Did police take the backpack away from Luigi's side while they were questioning him? Allegedly, yes. Allegedly, they took the backpack away from him and then searched it after he was already arrested for the fake ID. So they're claiming here that is illegal. That the search of the backpack by the police without a warrant was illegal. And that the officers questioning Luigi for all of that time and getting answers from him are illegal. That those should be suppressed. That those items should not be allowed in the trial. And that would be, the Pennsylvania trial about his fake ID, about his other items that were, illegal and related to the New York trial. He was really good at Resident Evil's inventory management. He was, true. I think he might have gotten some practice in Resident Evil. So there's a lot to unpack here. And I think, what we first have to ask ourselves is it illegal for police to search your backpack that you had when they arrest you? And the answer is probably not illegal at all. So this is what's called a search incident to arrest. A search incident to arrest occurs when you are in possession of items related potentially to the crime that you've committed in your immediate possession or control. If evidence is suppressed in one jurisdiction for another charge, can be used in a different trial on a different charge in a different jurisdiction. It depends. So to answer that, you have to think about a concept called collateral estoppel. Collateral estoppel basically means that in one trial, an issue is adjudicated. Here would be, the suppression of evidence. Most of the time, judges want to conform to the decisions that other judges made. So if one judge finds that this evidence should be suppressed in one case, another judge should think to themselves that that issue's been collaterally estopped and they should, conform to the decision. But they necessarily don't have to. These are both, different state courts, different states completely, different judges. One judge could choose to suppress it, and the other judge could choose not to suppress it. And, both of those issues could get appealed. That's what makes having multiple criminal cases difficult. So I want to talk first about the case of Schimmel v. California. So this is going to be kind of the case that decides what a search incident to arrest means. So in Schimmel v. California, police had an arrest warrant for Ted Schimmel for the burglary of a coin shop. The officers went into Schimmel's home, where his wife allowed them inside. Chat, if your wife is allowing you inside, if your wife is allowing the cops inside, tell your wife no. Chat, tell your significant other, don't open the door to the police. Police badge. Don't do that. The two judges should fight it out if their opinion is different. The stronger one is who chooses. No, we should not have judges physically fight each other. That would be hilarious, but no. Jesus Christ. When Schimmel arrived home, the police then arrested him inside his house. Without a search warrant, the police then searched his entire home, including the attic, the garage, and the drawers, claiming it was what's called a search incident to arrest. So basically, these guys have an arrest warrant for Ted Schimmel. That means they can arrest Ted Schimmel. Once they arrest him, once he comes back home, they then start to search his entire home looking for shit based on this idea that they can search for items close to where someone was arrested. The Supreme Court, however, we got these holdings here, found that the U.S. Supreme Court ruled 7-2 in favor of Schimmel reversing his conviction. The court limited the scope of searches incident to arrests, holding that police can only search the arrestee's person in the area within their immediate control. Here, the searching of an entire house beyond the arrestee's immediate reach requires a warrant. And this overturns some existing case law. So basically, you can only search incident to arrest what's, within someone's immediate control once they're arrested. So if we go back to the motion, we look at the backpack again. The backpack was within Luigi Mangione's immediate area of control when he was arrested, and it was on his person. There is no reason why the police should not be able to search that after they've arrested him. That's what's called a search incident to arrest. I don't see any way this search could be illegal. Now, that being said, then we have to think about, let's say hypothetically, the judge says, well, he wasn't in real control of that, and the backpack, wasn't related to the crime of false identification to the arresting officer, which is why he was arrested in Pennsylvania for giving a fake ID. Well, then we have to think about, are there any other bases for why the cops could search all of your shit? And that is what's called an inventory search. And so a good case of that is coming from Arizona v. Gant. And in Arizona v. Gant, a Rodney Graham was arrested by police in Tucson, Arizona for driving with a suspended license. After handcuffing Gant and securing him in the back of a police patrol car. Wait, did I get this mixed up? I did get these mixed up. 1 second, chat. I'm so sorry. For inventory searches, we're going to be looking at South Dakota v. Opperman. Chat, type 1 if you're just understanding anything. Type 2 if, Magic Lawyer Man isn't doing a good job of explaining things. Just ask me some questions. Guys, you guys can get in here, ask me some questions. I just want to answer your stuff. I want you guys to interject. I want to make fun of you a little bit. Let's get into this. Look, Luigi was just on his way to Boo on the board to steal Donkey Kong stars, okay? The bag just happened to be there when he visited Boo. He had the coins. He was good to go to steal DK stars and win the game. I don't see the problem. Welcome in, Aki. Exactly. They just happened to be there. It was unrelated. 100%. Are we defining immediate and control soon here? No, we're really not. Immediate control just means, within your vicinity. If he is wearing a backpack and if he's in a McDonald's, we would agree that backpack's within his control. So in South Dakota v. Opperman kind of allowed for these inventory searches to be legal. So what's an inventory search? Aki, I appreciate the gift subs, my guy. Chat, if you're not following Aki, you absolutely should be. They're a delight. She's really cool. Absolutely. Are you saying bye, funny lawyer man? Bye, funny lawyer man. Bye, Aki. Yes, we're talking about Luigi. So in South Dakota v. Opperman, Donald Opperman's car was impounded by the Vermilion, South Dakota police for illegal parking. Following standard police inventory procedures, officers searched the vehicle without a warrant. During the search, they found marijuana in the glove compartment. Opperman was then charged with possession of marijuana. He moved to suppress, arguing the search was unconstitutional. However, the U.S. Supreme Court narrowly found in favor of South Dakota and upheld the constitutionality of what are called inventory searches conducted by police as part of their community caretaking function. Chat, type 1 if you think the police really care about their community caretaking function. And because of their community caretaking function, the search of Opperman's car was ruled lawful, even though it was done with a warrant. So, inventory searches of lawfully impounded vehicles, of owner's property while in police custody is permissible under the Fourth Amendment to protect owner's property, to prevent claims of theft or damage by the police, and ensure officer safety for checking for weapons or dangerous items like bombs. Because the search here in Opperman followed standard police procedure and was not investigatory, it was deemed reasonable. So here, with the backpack, it was searched again at the police station as part of normal inventorying. They took, if we go back, you can see that they took, an inventory item of what was inside of it. See, this is an inventory of seized property. So that is, part of their normal searches. This is to make sure that we're not getting Luigi's backpack, and Luigi's backpack has a bomb in it that's going to blow up inside the police station. We want to make sure that doesn't happen. Would that be cool? That's for you guys to decide. But we want to make sure that doesn't happen. So, looking at this then, we're in a situation where this search of his backpack could either be justified under a normal inventory search, like here, or, a search incident to arrest, which, they originally did in the McDonald's. So I don't see any way how this could be unlawful. So the only other item we have then are his statements, him saying, "I'm Luigi Mangione," in the McDonald's. Well, I think there's some more bite to that. Because, chat, If you're American, you have Miranda rights. Chat, type one. Chat, tell me your Miranda rights. Let's see if you guys can get all of them. You got a right to an attorney. If one, you have a right to remain silent. You got a right to an attorney. If you cannot afford one, one will be provided for you. Shut the fuck up. Those are your rights. I have the right to remain silent. Right to shut the fuck up. That's absolutely what you should always do, chat. So let's talk a little bit about Miranda. So Miranda holds for the key standard that a suspect has to be in custody, not free to leave, and subject to interrogation by law enforcement for what are called so-called Miranda rights to apply. Does the Fifth Amendment's protection against self-incrimination extend to police interrogation of suspect? Conclusion. The Fifth Amendment requires that law enforcement officials advise suspects of their rights to remain silent and obtain an attorney during interrogations while in police custody. So we have to go back and we have to ask ourselves, was Luigi in police custody when 10 police officers were preventing him from leaving and the cops kept his ID from him? I would say he is. I would say any reasonable person, if there's 10 cops blocking you from leaving and one of them has your ID, you can't go. Well, okay. Were they interrogating him during this time? That gets a little bit murkier. So if they're asking him to identify himself, based off of criminal suspicions that he's Luigi Mangione, and just identify himself, I don't think that's an interrogation, especially back when there was just the two officers coming over to chat. But if he says more things over those next 25 minutes of being blocked by all these officers, that's a problem. Didn't they remove him for his backpack for 20 minutes? Also, yes. What is the law enforcement punishment for not invoking Miranda rights? Does that mean the evidence is inadmissible? Yes. So the punishment for law enforcement not invoking Miranda rights is a motion to suppress like this, for it to not be used in the trial. This is what's called, no. The officers won't even get a paid vacation, Mex. There's probably just a slap on the wrist. Here, did they have reasonable suspicions to be detained? They had reports that this guy was Luigi Mangione. So yeah, I believe they had reasonable suspicion not to be detained, Bull. To detain someone, you usually need to have, probable cause to arrest someone. But, if you have a criminal suspicion to do a Terry frisk like they did, and to do an investigatory stop, which is what I would call those first two people talking to Luigi, that's an investigatory stop. I think they have enough. But, when you have 10 attorneys and you continue to talk to someone and ask them questions and interrogate them, then no, everything he said after maybe those first 2 to 5 minutes should be thrown the fuck out. That's not okay. He was arrested in Pennsylvania, right? Pennsylvania is in the stop an ID say, so they shouldn't be checking his ID unless detaining him. Iggy Bo Biggie Boo. Great name, by the way. A little bit different. So in a stop an ID state, an officer can just stop you and ask you for your ID and, get that information. Here, he was in a private establishment, and it sounds like the private establishment thought he was Luigi Mangione. They wanted him out, and they wanted the cops to investigate that. So this is an investigatory stop on private property where he was kind of being trespassed out of. So I think them approaching him, them asking these questions, probably legal. But once you have 10 officers detaining him basically by taking his ID, taking his backpack away from him, and then at one point putting him in handcuffs and continuing to ask him questions, I think all of that should probably stop. Now, you might be saying, well, if them questioning him about his identity, for example, and getting that information during the investigatory stop under the detainment was probably illegal, then what can they do? So, you know, usually when you exclude evidence, it's gone, and you have what's called the fruit of the poisonous tree. The fruit of the poisonous tree means that all evidence the cops would get after, that initial stop would be illegal. Would not be illegal, but rather would be suppressed. So let's say the cops arrested him, based off of the false identification that he gave during his talk. Well, he was also being, arrested for being Luigi Mangione, for being the suspect for a completely separate reason. Because there was a completely separate reason for the arrest, the fruit of the poisonous tree, great band name, by the way, might not apply. So this comes from a case called Nix v. Williams. So let's talk about this case really quickly. So in Nix v. Williams, a Robert A. Williams was arrested for the abduction and murder of a 10-year-old girl in Iowa. After being read his Miranda rights, he invoked his right to counsel, like anyone should. While being transported by police, officers engaged in a conversation, expressing concerns about finding the victim's body before a snowstorm. Feeling pressured, Williams led the officers to the girl's body. Williams then argued that his statements and the body's location should be suppressed under Miranda v. Arizona and Brewer v. Williams, which had already ruled that his right to counsel had been violated. Police can't pressure you to talk to them by saying, "Oh, jolly gee, it's such an awful thing that we're not going to be able to find that murdered corpse, that murdered child, and after this snowstorm, those parents really won't be able to have, any closure. Oh, jolly gee willikers, I wish someone could help us with that. But that guy just invoked his right to counsel. That monster. He won't speak to us so that we can give closure to this parent. Oh, what is that? You know where the body is? That's crazy." You can't do that. You can't pressure someone into speaking after you've invoked the Miranda rights like that. And this was all done while he's in the squad car. Or not in the squad car, but, engaging in a conversation with him. So, without his lawyer present. And he'd already invoked his right to a lawyer. So, the trial court in Iowa allowed the evidence under what's called the inevitable discovery doctrine. But this was, overruled by the Supreme Court, who ruled that Williams' statements were obtained in violation of the right to counsel. On the retrial, the prosecution did not use Williams' statements about where the body was buried, but argued that the police would have found the body anyway because the police were already searching in the area. There is so much to this case. Williams was then convicted again and appealed. So the U.S. Supreme Court basically asked, whether the inevitable discovery doctrine applied. So the U.S. Supreme Court ruled 7-2 in favor of the state of Iowa, establishing the inevitable discovery doctrine, which states, illegally obtained evidence is admissible if police would have discovered it through lawful means anyway. Since a large-scale search was already underway, the court concluded that the victim's body would have been found regardless of Williams' statements. So basically, evidence obtained unlawfully is still admissible if police can prove they would have found it through legal means. This creates an exception to the exclusionary rule and the fruit of the poisonous tree doctrine. So basically, chat, if the cops can demonstrate, we would have found out he was Luigi Mangione anyway, or we would have found the information that he was stating in his interrogation, then we can use it. Then what does illegally obtained even mean when they can use it anyway? Elo, that's a fantastic question. Very little. If police can prove that they would have figured it out anyway, then your illegal statements become legal. The fruit of the poisonous tree doctrine doesn't apply. Here, they would be able to demonstrate that if they had, arrested him for being Luigi Mangione, for doing this crime of, murder, They would have done an inventory search of his bag. They would have found his passport saying he's Luigi Mangione. They would have found the false IDs through an inventory search of his bag, or by the or by the search incident to arrest concept that we were talking about earlier. So basically, even though they likely violated all his Miranda rights by asking him these questions, any statements that he said under that illegal interrogation can still be used against him if they're corroborated by other evidence they would have gotten anyway. So could his ID statement be thrown out if he had not had his passport with him? Potentially. But, with facial technology, how it is, it's completely possible that the cops would be able to prove that they could have identified him anyway. So Luigi Mangione, 10 officers detaining him, illegally, question him for 25 minutes, search his bag again. Will it be thrown out? Probably not. Because all of this stuff seems like items and questions that would have been, discovered anyway. Through the Nix v. Williams exclusionary, kind of exception to the exclusionary rule. So, that's lame.